begin with appearances on the record, please?
My name is Tim Eyman, pro se plaintiff.
My name is Leslie Griffith. I'm the Deputy Solicitor General of the Attorney General's Office. I represent defendants Governor Inslee, Ecology Director Laura Watson, and the state of Washington.
Thank you. Before the court today is the defendant's motion to continue, and my understanding in reviewing the file is that this is a request essentially for a partial continuance under CR 56F. I will hear from the parties, but I understand this to mean that there is a summary judgment motion that is currently set before this court on April 15, 2022. And my understanding is that the defendants do not object to part of that motion being heard on that date, but are requesting a continuance as to part of that motion scheduled for April 15th. I say that just as a preliminary matter of my understanding. It may be incorrect, so I appreciate the parties providing any explanation to that. I reviewed all of the briefs filed regarding this motion. I will say that I have not thoroughly reviewed the motion scheduled for April 15th. I reviewed documents regarding this motion and the file generally. I am not prepared today to address the merits of the motion scheduled for April 15th. I will be then, but I am not today. So what is before the court today is only the motion to continue. And I will hear from Ms. Griffith first. I would limit the parties to 10 minutes per side for argument. Ms. Griffith.
Good morning, Your Honor, and just as an initial point, your understanding is correct as far as we know. I feel like we have been unable to confirm whether that April 15th date is in fact on the calendar. We did get a notice for it, I believe, on Wednesday, but the Odyssey has just never been unable to access this week. So that's my understanding, but I just haven't confirmed that it's actually on the calendar. So I'll lay out where we are this week other than that, and then make 3 quick points. The bottom line is that we're squarely in the type of situation that Rule 56F was designed for. We've pursued discovery without delay. We've identified a set of discovery that's incomplete, and that discovery is relevant and material. Especially so early in the litigation, it would be most fair to continue dispositive motions with regard to the merits of the Clean Fuel Standards claim. So that's one of the 2 bills at issue here, or for which Governor Inslee's partial vetoes are at issue here. So where we are this week, we're at the beginning of this litigation. The legislature responded to our subpoena from February 15th, just this past Tuesday, and indicated that they would begin production in batches next week. We don't have a full timeline for what they anticipate for their production. We told the legislature early on, back in December or January, both when Mr. Eyman and the fifth complaint, when the legislature filed their own actions, that our plan was to pursue discovery against the legislature, and they've never suggested that they believe discovery is fully irrelevant or fully inappropriate. I also wanted to note that the legislature is coming to the end of its short session this year. That'll be, I believe, the end of next week. And we do want to bring to the court's attention that there is legislation pending that would raise pretty serious mootness concerns with regard to both statutes at issue in this action. So we are monitoring that. Nothing is done until it's done. But I did want to bring that to the court's attention since we're nearing the end of the session. The end of the session also means that the legislature will be have more time available to respond to our discovery, and we can better assess the progress of that. So with that, a continuance under Rule 56F is appropriate here because we have promptly begun discovery. We are simply seeking a continuance to allow us to get responses to that discovery and do any necessary follow-up. It's really important to both Governor Inslee and Director Watson that this litigation proceeds quickly. We want to remove any cloud or uncertainty that's over the programs because of active litigation. And that's especially important with both laws because there are statutory deadlines for implementing regulations. We don't want any confusion as the agency proceeds along that schedule of implementing implementing and we're standing up both the Fuel Standard Program and the Climate Commitment Act program. With regard to the Climate Commitment Act especially, it sets up a market trading system for emissions allowances, and we don't want any uncertainty for the regulated community as that gets up and running. So we have an interest in moving this litigation along. But we also want to make all available arguments to us, and we want to make a full record for those arguments. And we do believe that some discovery is appropriate and necessary to doing so. And plaintiff's premature summary judgment motion short circuits that. Second, legislative drafting strategy is squarely relevant to the merits of the assessing the partial veto of the Clean Fuel Standard claim under Locke, Lowry, and Inslee 1 from last year. Those cases make clear that if legislative drafting is not true to the spirit of the Constitution, then the designation of something as less than a full section by the legislature is not conclusive, and the court must uphold the governor's veto as a proper exercise of his section veto power. Now, when we get to dispositive motions on the merits of the Clean Fuel Standard, we plan to rely on the language, history, and structure of the bills to make clear that the legislature intentionally inserted the effective date delay provision to thwart the governor's veto. We'll lay out how the Clean Committee asserted in these bills an identical provision that would have delayed implementation of key portions of the bills. It was designated as a subsection, even though it affected provisions of the bill throughout the entire bill, not just that particular section that the delay provision was contained in. That all should be clear from the legislative language and history, and as you said, that's something that we can go with at actual summary judgment. But we also think it's likely, because of that way that the bills were amended and passed, that there was coordination in the legislature and that direct evidence of a legislative strategy to evade the governor's veto is out there. Now, direct evidence like that of manipulative drafting might be rare, but when it exists, we think it's important that discovery be available to make a full record of that. We recognize that there are circumstances in which discovery in the legislative drafting will be unwarranted or unnecessary. But in these narrow circumstances where legislative drafting is directly at issue and we're not challenging the validity of the law itself, targeted discovery is relevant and material. And a premature summary judgment motion makes achieving that impossible. Finally, and I might say more about this on rebuttal, the veto case law means it says that each veto needs to be considered on its own terms. You look at what exactly was vetoed, what the drafting and amendment history was, the overall structure of the bill. And that's why we believe that Inslee 1 does control here. That concerns the question of what is an appropriations item versus, what is a section. And it also involves just different statutory language and different bill history from both the Clean Fuel Standard and the Climate Commitment Act. So not only is Inslee 1 not controlling, but that's why we're asking to treat the merits of these two different claims in Mr. Eyman's lawsuit differently. With regard to the Climate Commitment Act, the governor vetoes what the legislature designated as a whole section, and then some fragmentary cross-references to that section that are basically ministerial. So with regard to that claim, the court doesn't need to reach the issue of legislative drafting and whether something was a de facto section. So that's why we're comfortable proceeding to the merits without discovery there. With regard to the Clean Fuel Standard and the merits of evaluating that veto, we think this is squarely in the Locke, Lowry chain of cases talking about whether legislative drafting is a palpable attempt at dissimulation. And so that's why we're seeking discovery on that, but not the Climate Commitment Act veto claim. Now, Mr. Eyman moved for summary judgment just as this case was getting underway. We have repeatedly told him that we intend to seek discovery of the legislature, and now we have sought discovery. We've offered, as recently as this Monday, to discuss negotiated schedule for dispositive motions. We do think that schedule needs to accommodate some basic targeted discovery with regards to the merits of the Clean Fuel Standard claim. For that reason, we think a partial continuance is appropriate. Thank you. And I'd like to keep a couple minutes for responding to Mr. Eyman.
Thank you. I will give you that, but I have a couple of questions first.
Sure.
So I appreciate that the parties may have a clear understanding of what a partial continuance is. I do not, however. it seems to me the court is very well aware of an appellate record in every decision that it makes, that it would be beneficial to the court to address all of the issues in a motion together, or require that a separate motion be filed. So I would like to hear your response to that. And then my second question is, what kind of continuance do you believe is necessary? What date do you believe that discovery would be completed such that the court could address all issues on the motion for summary judgment currently scheduled for April 15th?
I appreciate Your Honor's request for clarity on a partial continuance here, and I think, one reason we have split those up is because of, as I said, there is an interest in our clients in resolving this litigation, and if we can resolve part of it before we resolve all of it, I think that helps move things along and provide that regulatory certainty. So that's why we're comfortable with resolving as much of the case as we can on that April 15th date, assuming that it is on the calendar. As for whether that means that there need to be two separate motions, that may be the case. And we may also be filing cross motions. That's one of the reasons we were hoping to sort of negotiate a schedule here to make that easier. If necessary, we would be comfortable pushing everything out to a later date and resolving it all at once. I think the reason we like that April 15th date on the calendar also is, one, so we can resolve the Climate Commitment Act veto. But two, if there are mootness issues, I think we would probably, or other threshold issues, we would want to go ahead and get those taken care of at that April 15th date. And then with regard to your second question, we are in the early stages of discovery here. We don't know quite what the legislature has in mind for our production schedule, and we've offered to meet with them to resolve any objections they have.
What is your request of the court?
We would like, we would be comfortable with, a tentative discovery ending date in June, and then the court asking the parties to provide a status, to have a status report a week after that, to find a date for dispositive motions.
You're seeking a continuance of the motion for summary judgment as to a particular point. What are you seeking a continuance to? What is the date you are asking the court to continue the motion to?
As for when the court would hear the motion?
My question is, what are you asking for?
We're seeking a continuance of the motion. So both our response to the motion and any hearing on the motion until after discovery is complete. And I'm saying this, we could say discovery would be complete as of June 1, and then.
July 1. I'm just trying to get an understanding of what you're requesting. The motion could be heard after June 1, June 15, July 1.
I think we would tentatively say the motion could be heard after June 1. We would reserve the right. We don't know what the legislature is thinking as far as the timeline, but that seems reasonable to us for now.
Thank you, Mr. Eyman.
I guess my major point is that they've had an extraordinary amount of time to be able to prepare for this. They're asking you for a continuance. Your Honor, I feel like I've already given them a continuance because I have struggled to be able to file the proper paperwork in the proper manner in order for them to be able to move forward. Here we are in April, which is 5 months after my original complaint was filed in this case. And on November 5th, before I even filed the case, the governor's office asked a public records request of the legislature of this exact same set of information. And the response I got when I went to the public records officer was, I said, I want those same documents that you asked for back on November 5th. And she responded, the records you are seeking are documents that were produced by the legislature to the governor's office. But they said the records in our possession are privileged and they cannot be produced. I said, I want them even if some of them are redacted, which I don't understand why a public document would ever have to be redacted. And nonetheless, I was denied from doing it. They already have the documents that they're talking about. If they had something, the smoking gun, they could show it to us now. The idea of delaying this thing any further, I believe, does not serve anybody better. I think the April 15th date, again, 5 months after the original complaint was filed, is plenty of time for them to be able to go fishing around to find something that they think is going to justify what he did, which is looking at the bill, getting rid of a subsection, getting rid of individual words, getting rid of individual sentences. But my major point that I would also just re-emphasize, other than me already granting them 5 months continuance already, is the governor was in on the delay provision. In my amended complaint, I pointed out, quote, Governor Inslee, in order to pass the bill, struck a deal with legislators to include a delay in the legislation. But when the bill arrived on his desk, he broke his end of the bargain and vetoed that subsection. It cannot be that they manipulated the situation when he was in on it. If he's part of the process that's going forward, the idea that somehow they move things around with him without being aware of it, it's almost like he's accusing them of what he's guilty of, which is I apologize. Sorry, go ahead.
That's okay. I need to interrupt. So there is a person on the Zoom call that is not muted. I'm unable to mute them, but they're making some background noise. If everyone mute themselves so that I can hear clearly, I don't want to identify that person on the record, but if everyone could please mute themselves so that there's no background noise, I appreciate it. Thank you. My apologies, Mr. Eyman.
No, I appreciate you saying that. So again, we're kind of back to the enroll bill doctrine, which is the bill is what the bill is. It's right before you right now. You're able to, and I've done everything I could to have this expeditiously decided, but nonetheless, because of my own inability to properly be able to file these things and get them noted up on a calendar that meets with Your Honor's scheduling, and marking a box for other motions rather than the box for dispositive motions has given them an extraordinary amount of time to be able to prepare. If you deny their continuance thing, they have from now until April 15th to review all the documents, which they already have, to be able to find this smoking gun information. But as I reiterate, Governor Inslee was negotiating with them, and he agreed to include the delay in the legislation itself. And so therefore, the idea that somehow they did something behind his back, if anything, he seemed to pull the rug out from underneath them. He negotiates a deal, puts a delay in it, and then strikes it out. The problem we're having is it's now nearly a year later, and two policies that the legislature said they didn't want to have take effect immediately took effect immediately a year ago. And justice delayed is justice denied. This should have been decided a long time ago. The only reason it's now before the court at all is because of your ruling, because the Supreme Court upheld your ruling, and 3 days later I filed a complaint because nobody else was filing any complaints about it. It is a maddening process that this has taken this long already. I believe April 15th is a reasonable amount of time for both parties to be able to prepare, and I believe the case is self-evident that he's not allowed to veto individual words, individual sentences, subsections. It's all before the court already. The smoking gun emails, which are privileged and cannot be produced to me, doesn't make any sense because, again, these are all public documents. So I'm angry and frustrated that I asked for the exact same materials that they asked for on November 5th, and they've already got them. So I would respectfully request that the court deny the partial continuance, because as you pointed out, they can't even figure out when they think they might get what they think might have something in it. And it should be both together, because there were two bills originally brought forward in the complaint, and both of them he did the same thing that he was found guilty of, or found that he exceeded his authority by the Supreme Court. I think Inslee 1 is operative, and that there's no huge difference. Final point, this is brought under a CR 56D summary judgment motion, so it's really up to the court to decide what kind of substantial controversy there is. And so far they're basically saying, give us more time so that we can maybe find some. Even if you think they may have something, they would already have it, and they could show it to you in camera if they had to, if they think that there's something relevant to it. So I appreciate your consideration. I have done the best I could to move as quickly as possible, because I want this resolved as quickly as possible, yet I've given them 5 months to be able to prepare. I think that's more than enough for a very straightforward case, which I believe Your Honor is very capable of being able to examine. Look at the bills, words, sentences, subsections being vetoed. You can't do that. That's what he did before, and I would ask you to deny their request for more time.
Thank you. Ms. Griffith, you have 2 minutes remaining.
Sure, thank you. And I'll clarify what I believe Mr. Eyman is referring to. My understanding is he sent a public records request to the Attorney General's office seeking documents that had been produced to the governor from the legislature in response to that November 5th public records request. My understanding, I don't think I was on this communication, is that the Attorney General's office, public records folks, directed him to seek documents directly from either of the legislature or the governor. From what I understand, the governor's office is responding to that public records request that went to the governor. There are some documents that have been produced to the governor in response to that request, and that production is ongoing, as is the discovery. And I think it's fairly standard for public records requests and discovery to take a significant amount of time. But the overall point is that the case, the amended complaint was only in December. We have pursued discovery. We do not anticipate, needing to drag this out, and we have no interest in dragging this out. But we believe that direct evidence of legislative drafting is relevant and material. We fully intend to make arguments based on the words of the statute itself and the history of the statute itself. And we believe that they should make that clear that the governor's veto was constitutional. However, we also want to make all arguments available to us, and we believe that some discovery is appropriate. And I'm happy to answer any other questions.
Thank you. I have none. The court is prepared to issue a ruling at this time on the motion to continue. I note that the parties each have a very different understanding of this case. And the court has probably even a different understanding of either of those. The court looks at each case individually and each motion individually. I want to say that arguments regarding the underlying case, including whether the prior case is controlling or not before the court today. Whether there is some mootness issue, not before the court today. This is a motion to continue the part of the summary judgment motion because of discovery. So I want to be clear that there is a particular burden on the party requesting a continuance under 56F, and that is the standard by which the court determines this particular motion. I am not addressing the merits of any argument today. In fact, the court is unable to even determine what might be necessary in terms of the record for the court to address the merits of the case. The parties dispute that. That is not unusual. One party claims that additional discovery is necessary. The other party claims that no discovery is necessary. That's why there is a clear burden under 56F on the party requesting the continuance. I also want to say that this summary judgment motion is not premature. A summary judgment motion may be brought at any time in the litigation after an appropriate time of party appearing, answer being filed, etc. And so it's not premature, but that is the reason why 56F exists, because it may be that additional discovery is necessary for one party. And again, it is the burden of the party making the motion to show that discovery is necessary in order to address that. Here, the defendants have met that burden to show that discovery is necessary. That doesn't mean that the court believes that it's necessary. I do not know. That burden, though, has been met to show that additional discovery is necessary in order to address the merits of the case, which, again, the court is not addressing today. Any exchange of information that occurred prior to the litigation is, again, not relevant for the court's consideration as to this motion. There have been no prior continuances, although the motion is early in the life of the case. Again, I wouldn't use the word premature. It's early, but it is appropriate for a continuance in order to allow discovery. The parties requesting discovery may or may not be successful in obtaining that discovery. Once again, that's not unusual. The court is not making any finding that the documents or evidence being sought exists or will be exchanged. It is the court's role to determine whether the burden in 56F has been met, and it has. I appreciate the parties, all parties, moving quickly on this case, and it has moved quickly, despite what has been stated on this record. The procedures of this court are important and must be followed. That includes marking proper boxes on forms and using proper forms. That makes a significant difference to the court in setting hearings. As the parties know, the court clerk is a separate entity from Superior Court. The court itself does not set hearings. The court clerk does, and I appreciate the parties being in communication with the court clerk regarding that. The court has no control over the Odyssey system or setting hearings. That is the court clerk. And I know that that has been the source of frustration. Frankly, it's been a source of frustration on the part of the court as well at times. But I believe that in following proper procedures, the parties are able to get hearings set. In addition, this court is open to setting hearings over cap or at a special time if a party requests it timely and appropriately, and it can be done. I'm not saying that this case merits that, but any requests of the court can simply be made to the court by noting up a motion. The proper procedures must be followed in order to set a hearing before the court. The next thing I would like to say is that it's appropriate to have a continuance to complete discovery for the argument that is being requested. Both sides are asking the court to address the arguments that do not require discovery on April 15th. I can do that, but only if the record is clear what the court is hearing. So if the plaintiff wishes to move forward on April 15th with a summary judgment motion, I am asking and requiring that the plaintiff file a separate and supplementary motion for summary judgment by March 15th, reflecting those arguments that are not continued by the court's ruling today. And then the parties should file appropriate and timely pleadings in order to have that matter heard on April 15th. The court will allow a motion for summary judgment on the continued matters on or after June 3rd. I do not know what the court's availability is on June 3rd or any other date, but that is the date to which the court is continuing, allowing the plaintiff to move for summary judgment. So I'm not setting a hearing on June 3rd. What I anticipate is that the parties may confer and review the court schedule to determine what date works for them. Do the parties require further clarification of the court's ruling? Ms. Griffith?
No, Your Honor.
Mr. Eyman?
Yes, the June 3rd date that you cited, that is the day that I could file a motion for summary judgment and then have it heard 28 days later, or is it that I could do a notice of hearing for June 3rd and would work backwards from there and essentially be filing the motion for summary judgment on May 3rd?
Excellent question. The latter. So the first time that a hearing could be set would be June 3rd.
Set.
Consistent with all of the procedures of the court and the timelines that you indicate. Does that clarify?
It does. And that they would have from now until then to complete their discovery.
Indeed.
Okay.
Obviously, subject to further order of the court, which I am not in any way inviting, but that is always the case.
Okay.
Anything else for today?
Would the one that is being heard on April 15th, which is a separate motion that's being filed no later than March 15th, would that be marked as a partial summary judgment, or would that be summary judgment solely on this one bill, if that makes sense? Because the original motion or the original complaint was over two bills, I'm wondering how you would prefer to have the new one set so that it's only addressing one of the two.
So I will say this. I am not placing any limitations on the brief that is filed no later than March 15th, other than it may not contain a motion for the issue that the court just granted a continuance.
Okay, very good. That helps me enormously. Thank you for that.
So I would ask the parties to confer regarding the form of an order regarding the court's ruling today. If that is agreed, the parties may use one of the two ex parte processes for getting agreed orders signed, either through the court's telephonic process or the clerk's process. If it is not agreed, a proposed order may be filed and set for a hearing for entry of order. Any questions regarding that?
I did have a question on another topic, so when you get an opportunity for that.
Go ahead.
The public records officer said that they did already produce these documents to the governor's office, and she said they're privileged and cannot be produced. Can the court order the Attorney General's office to turn those over? Because
so I'm not addressing any other issues that were not set for hearing today.
Fair point.
If any party has any other motions to bring before the court, they can be properly noted.
Excellent. Thank you for that.
Thank you. And we are completed on this matter for today.